Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate. In today's class, we will discuss an important concern regarding quashing of the FIR or charge sheet concerned with the offences of forgery and cheating. As we know that whenever there is a compromise of accused and complainant concerning offences of forgery and cheating, the possibility to dispose of the case is on lesser side. The reason is that the offense of cheating is compoundable, but the offense of forgery is non compoundable. So we could not take any benefit from the consent trial code. So, what we can do and how to proceed? So, we have to understand the recent judgment of Honorable MP High Court, which is dated 19th of Feb 2026, and have to follow this step in case there is a compromise between us and the concerned complainant concerning offences of forgery and cheating. First of all, we have to draft a proper compromise deed. In the deed, we have to mention that the concerned parties have settled their score, nothing is pending, and the concerned complainant is not willing to pursue the matter. The concerned compromise deed could be executed on a stamp paper of rupees 500, and it is required to be executed before notary also. And after that, we have to file an application before the concerned trial court regarding the disposal of case based on the compromise. As we know that the offences of cheating are compoundable, so up to the extent of cheating, the compromise will be accepted. But as far as the offense of forgery is concerned, it is non-compoundable. So the plea would not be accepted and your consent application would be rejected up to that extent. There is no need to file any revision before court of session. Directly we have to file a petition before Honorable High Court as per section 5 to 8 of BNSS. So basically, if the FIR is under section 318 subclause 4, section 338, section 336 subclause 3, section 340 subclause 2, section 61 subclause 2 of BNS. First of all, even in the petition, we have to specify that the compromise has been occurred between the parties. Number 2, the compromise deed had been enclosed. Number 3, we have to show that there is no pressure, threat, or coercion or inducement. The concerned complainant, as per his free will, executed the compromise deed, and we have to specify that the concerned complainant is having no intention to pursue the matter. So basically, if the petition is filed, the court may hold the inquiry, or court may direct any agency or any authority to hold the inquiry to find out whether compromise is as per free will or it is with pressure, threat, coercion, or inducement. So if the report says there is no pressure, threat, coercion, or inducement, and apart from that, the complainant is having no intention to pursue the matter in consequence of compromise, the concerned case could be quashed. And apart from that, we have to rely on two important judgments of Honorable Supreme Court. One is 2024 Volume 10 SCC, page 384. Other one is 2008 Volume 16 SCC, page number 1. So basically, if the offense is having a civil flavor, means the offense has been arisen from a civil transaction, and the victim and the accused, if settled their dispute, in that scenario, the proceeding could be quashed. So basically, the steps are required to be followed so that we could chalk out a good case and could avail the remedy as per law. So I think that I have specified you the points to be followed in case compromise occurred between us and the concerned complainant regarding the offences concerned with forgery and cheating. See you in the next video. Till then, Har Har Mahadev, Jai Shiv Shambhu.